today on oral argument. We'll start with United States versus Michalik, and I'm probably mispronouncing that, in which case I welcome a correction. And Mr. Bartolomei? All right. Yes. It's all yours.
Thank you, Your Honor. Good morning.
Morning.
My name is Richard Bartolomei.
You can remove your mask.
Yeah. My name is Richard Bartolomei. I represent Jeffrey Michalik.
Yes.
I will be addressing a motion to suppress. I was also one of the trial lawyers, should the court have questions, particularly about things occurring in trial. Mr. Michalik challenged in his motion to suppress the Fourth and Fifth Amendment. The Fourth Amendment was based upon his immediate seizure and detention at the side of the vehicle. The search warrant that was being executed had no provisions for detentions of any individuals, and he was immediately detained. He was continuously detained thereafter throughout the entire interrogation process and was followed to his place of business, followed by 2 cars with armed agents. It is our contention that the court did not make the particularized findings, deciding this case essentially on credibility, where I have characterized it as almost a presumption of the agent's credibility. Going through the facts of this case very quickly, 3 agents approach at 6:30 in the morning. The defendant is getting into his car. They instruct him that he has to go back and help them get into the house. There is no provision for such a detention. He has no such obligation. He then helps them into the house by opening the door at their direction. They immediately have his keys to his car, and they have his cell phone. He is required to yell to the occupants, come down, come out. As this court has probably seen, there's a security sweep. The surveillance indicated to the agents that there may be as many as 5 people there. They bring somewhere between 6 and 8 armed agents in full protective gear with assault rifles and weapons. Shock and awe is effective. The individuals come out, meaning from within the house. Ms. Osuna, 13 years old, her grandmother, Crystal Rivas, the fiancé, and they are ushered into the living room. This is essential because they are continuously, from that time, escorted everywhere within the house. They are escorted everywhere they go. They have to ask permission. Mr. Michalik is immediately...
Wasn't he told he was free to leave?
Excuse me?
Wasn't he told that he was free to leave?
That's a contention. We disagree. That's the part of the credibility issue. If he was free to leave, I would posit this: why wouldn't he have gone on to work to make his appointment?
Okay, well, there's 2 different issues, whether he's free to leave or whether he was told free to leave. Does he deny that he was told that he was free to leave?
Absolutely. And the reason we say this is, circumstances indicate if he had been free to leave, he would have left, and he said so. He testified. If I'd known I was free to leave, I would have gone on to work. Why would I give up the appointments? Remember, he doesn't have any apprehension that these people are coming. So yes, he denied that. Furthermore, they immediately isolated. And this is important because, as this court knows, even under...
He later drives himself to the office, right?
Excuse me?
He later drives himself to the office.
We will address that, yes.
Well, but it's just a yes or no question.
Excuse me?
It's a yes or no question. I'll explain why I'm asking.
Oh, yes.
He drives himself.
Yes.
So I get that there is a dispute about whether he was told whether he was free to leave or not, but doesn't the fact that he was later allowed to drive himself with the agents merely following him suggest that the consensual theory of events is at least not crazy?
No. Remember that...
Tell me why.
Very simply, he has armed agents following him. They follow him in their cars. Meanwhile, he's still held hostage.
I'm sorry, I want to make sure I heard you. Could you repeat?
Meanwhile, his entire family, to the best of his knowledge, is still held hostage in the house by armed agents. So...
I may be forgetting the facts. I thought that his family was specifically left to take the kids to school. Am I forgetting that? Or is that one of those facts in dispute?
That's an important fact. Ms. Rivas testifies, contrary to the statement that we told everyone they were free to leave, Agent DePaula acknowledges actually what she said was, you have to tell the agents, you have to get permission to leave. And the importance of this is, wherever they go in that house, they have to ask permission, and it's unrebutted, because remember, Agent Juarez and Agent DePaula are not there while the family remains in the house. So the point is the circumstantial evidence and the contrary testimony, unrebutted, was we had to ask permission to go to the bathroom.
Okay. Do I understand correctly then? Basically, it sounds like there's a fact dispute about everything. That the agents have one theory of what happened that is highly consensual. Your client has a very different view that is highly non-consensual. So it's a credibility call for the district court?
Well, credibility determinations are called for in this case. The interesting thing is the district court doesn't ever even talk about any of the contrary evidence that is unrebutted by Crystal Rivas and her daughter, which would have established exactly what the defendant said, which is, I wasn't told I was free to leave. They said we had to ask permission to do the smallest thing, and they were escorted.
Would your position be different if the district court had talked about the evidence on both sides?
Yes,
and then nevertheless found the agent credible?
Well, they at least, yes.
I'm trying to isolate what your quibble is here. Is it that the district court should make the credibility call, or that the district court is required to talk about both sides before making the credibility call?
Let me answer both.
Okay.
First of all, the directive in these cases is you have to consider the countervailing evidence, because you have to look from a reasonable person standard whether or not what was done and said would have affected the perception of a reasonable person. All of the evidence, both direct and circumstantial, is contrary to the agents, keeping in mind, as I pointed out in my reply brief, they don't have a very good recollection, and they testify from belief, lack of recall, probably, and they are permitted to do so. The point is, yes, I think this court does. You know, since Thomas and Keohane, that it's a mixed question of law and fact, which requires this court's independent examination.
All right, your initial time has expired.
Thank you.
When you come back up on rebuttal, give me the case that stands for the proposition that if the trial court doesn't iterate about all the arguments, it necessarily means that, we reverse. You follow what I'm saying?
Yes, sir.
There's a case, when you come back on rebuttal, just help me understand where we required the trial court to do that.
Thank you.
All right, Mr. Bartolomei.
May it please the court. My name is Richard Bartolomei II. I'll be addressing the erroneous admission of Exhibit 6B under the Federal Rule of Evidence 1006, and erroneous admission of the accompanying testimony, as well as the insufficiency of the evidence. Now, before trial, the defense had correctly pointed out that the previously disclosed Exhibit 6, which listed the contraband found in the laptop's music folder, did not show that anyone had ever opened it after it arrived on the laptop. So the day before trial, Agent Nutt directed CFA Linares to fill that hole in the government's case with a new Exhibit 6B, made with forensic software, a summary of link file information to try to show that someone had opened the child pornography after it was saved in the laptop music folder. Now, ultimately, both Linares and Nutt admit, even with 6B, they had no forensic evidence that Mr. Michalik or any specific person had opened or accessed any of the child pornography listed in Exhibit 6. Now, 6B was a summary governed by Rule 1006, which, independent from discovery rules, requires pretrial disclosure of the underlying materials at a reasonable time and place, and in a format readable by sight. It's not an image of an entire hard drive, which CFA Linares himself acknowledges even he can't read without forensic software. Now, United States v. Smith says this pretrial disclosure is very important. It's necessary to resolve summary issues by objections and motions in limine, to avoid the chief danger of summaries, which is that argument subtly woven into these summaries that's unchecked, becomes actual evidence of the argument. And admission without this pretrial disclosure under Hackett v. San Antonio Housing Authority is abuse of discretion. Now, defense counsel objected to 6B.
Now, is your argument that there was no pretrial disclosure or that it was just too late?
Well, my argument is twofold. There was no pretrial disclosure in the format required. The defense was given a copy of the image hard drive, which Agent Linares acknowledges is not readable by sight unless you have the forensic software. Rule 1006 requires the originals or duplicates of electronically stored information be in a format that's readable by sight. That's by reference to Rule 1001, setting the definitions for originals in 1006. So it must be readable by sight. And the reason for this, I believe, is clear that there is going to be a great discrepancy sometimes in the technical sophistication between parties. So we set down this broad rule in 1006 and 1001 such that anybody could get a printout or something readable by sight, figure out they can't use it, don't know what it means, then perhaps flip it to an expert who may be able to give them some insight into what evidence they will have to confront at trial. But none of that was done here. Defense counsel objected that this was an improper summary under the rule, a complete surprise, and required 2 weeks of forensic examination to even verify the accuracy of the populated fields in Exhibit 6. The district court admitted 6B on the government's mere proffer that 6B showed someone accessed files, and 6B would permit the government to argue someone had knowledge. But that's the purpose for why they wanted it in. It's not the foundation for why it should be in. Now, this error was complete upon admission and it couldn't be cured. Defense, in opening statement, had already informed the jury there would be no evidence that the Exhibit 6 contraband had been opened after it arrived. Very hard to put that toothpaste back into the tube, so to speak. 6B also permitted the government to sidestep expert disclosures. They admitted 6B through Linares, a lay witness. The government could then save Mr. Nutt for rebuttal. So Linares channeled Nutt's expert argument woven into 6B that the link files contained in 6B ipso facto show access after the contraband arrived, in violation of Federal Rule of Evidence 701C, and this court's precedent, United States v. Hart, which is very clear. You cannot use a summary to assume what you're required to prove as the operative facts of the offense, and if the summaries weave in expert assumptions, then those must be proven by experts. Linares was never disclosed or qualified through Rule 702, but he does perform a flawed forensic analysis at trial. He concludes that someone went into the music folder to view child pornography after it arrived October 18th and 19th, but this is contradicted in many ways by his own hard and fast link file timestamp rules. The relevant 6B link files at issue refer to the music folder itself and some of the explicit Exhibit 6 images. Now, timestamps like file created and last accessed that are reported in link files are supposed to match the timestamps in the underlying files themselves. The link files, as the government contends, do not give you any independent indication of when the link file was created, i.e. when the file was accessed. Now, before lunch, Mr. Linares doesn't know whether Windows updates last accessed when a user accesses a file or folder. He only pays attention to file created. File created is important to him because that is when he knows the file came onto the computer for the first time. After lunch, he claims Windows never updated last accessed after the initial file created date, and so last accessed is forensically insignificant, he says. Now, his own Exhibit 6B contradicts his testimony. Windows did update last accessed, and it updated it for the music folder itself. There are 3 records in 6B, records 28, 87, and 92, which link files reference the music folder. They show a last accessed 4 years after the music folder's 2011 file creation date. Now, in fact, those last access times are 1 second after 4 non-contraband images were saved into the music folder August 26th, 2015. The child pornography at issue in this case arrived October 18th and October 19th, and the 6B music folder link files appear to show nobody went into the music folder after that contraband arrived. The reason being, there are no music folder link files in 6B that reflect the last access time of either October 18th or October 19th. All 3 of the music folder link files in Exhibit 6B show a last access time of August 26th, 2015, 1 second after 4 other files were saved there, had someone opened the music folder, Nutt and Linares assure us that that would have created a link file, incorporating the timestamps from the underlying file, the music folder itself, and there are no music folder link files reflecting an October 18th or 19th date. Now, Agent Nutt then goes on to testify, further confusing and misleading the jury about 6B, but over objection, reiterating Linares' flawed link file testimony, despite no defense link file evidence presented and no defense expert to rebut.
What's the error you're asserting is reversible error for us? I mean, you're gonna run out of time just reciting to us the narrative, so you're arguing about 6B, so what's the reversible error aspect of it? If it is error, why wouldn't it be harmless error in light of all the other evidence?
Well, the reason this is a reversible error is because there was substantial impact on the jury's determination based on this evidence that we believe is inadmissible because there had been no foundation shown, that it was spoken about in violation of 701C by Mr. Linares, and that Mr. Nutt's testimony itself was improper summary testimony and rebuttal, replowing Exhibit 6 and 6B and summarizing it for the jury. And the jury paid specific attention to these link files. They spent parts of one day and a full day essentially asking for Nutt's testimony about these link files repeatedly, both by his name and both by the numbers that he called out. He called out 3 link files, 12, 52, and 90, which violate his own timestamp rules. He says, of course, the link files will incorporate the timestamps from the underlying file. He pointed to one child pornography file, Open F7, said there were 3 link files that referred to that file, so that meant it was accessed 3 separate times. The issue with that is the 3 link files predate by 3 days the arrival of Open F7 on the computer. I see that my time is over. If you'd like me to continue with that thought, I can.
You've saved time for rebuttal, thank you.
Thank you, sir.
And for both counsel for the appellant, so I noticed that you've reserved 2 and 3 minutes respectively for a rebuttal. Obviously, that's a total of 5. You can divide up that 5 however you wish, but you're only going to get a total of 5. So when it's time for rebuttal, Pam, if you would just set the clock to 5, and then these gentlemen can figure out how they want to distribute their time. Okay, Mr. Gupta.
May it please the court, Neeraj Gupta for the United States. If you can't hear me, just raise your hand or stop me. I'm going to start off with Exhibit 6B, unless you have a question about something else. For Exhibit 6B, there appear to be 4 separate arguments, sub-arguments for Issue 2, which is that there was some bad faith by the government in the timing of giving over Exhibit 6B, that the government's second witness, Linares, their forensic analyst, should not have testified as a lay witness about it, that Nutt, the government's forensic expert, should not have testified on rebuttal about it, and then there's an argument that's raised for the first time on appeal that this violated the Rule 1006, that it was a summary exhibit.
Also, a lack of foundation. I don't know, somewhere in there, the lack of foundation is part of those issues, I believe.
Okay,
At least that's what I heard this morning. I don't mean to cut off your
well, let's
thought.
see if we get there. And
I heard
prompt me
a
where
mention
that-
of lack of foundation. So.
where that argument comes in.
All right.
So starting off with Exhibit 6B, I think it's important. Judge Stewart picked this up, and I'll try to elaborate on it. Exhibit 6B, the timing of it didn't come from bad faith by the government. It didn't trick the defense. It was admitted because it was being used to rebut an incorrect claim made by the defense. And there was no prejudice because the court made accommodations in the trial. So I'm just going to try to organize that. It's a 3-day timeline, Tuesday, Wednesday, Thursday. The Tuesday before trial, trial started on a Wednesday. The Tuesday before trial was the suppression hearing. And for the first time, the defense made a claim to the court. We believe there is no evidence that these child pornography files have ever been opened on the defendant's laptop. That was the day before trial. So that night, Tuesday night, the forensic analyst ran this report that was eventually made into Exhibit 6B, and then it was given over to the defense the next morning, Wednesday morning, the first day of trial. So that's the timing issue. There was no withholding, there was no bad faith. The exhibit was created when the government heard this incorrect claim for the first time and given over the next morning. Now, as to the second claim that was just made, that defense counsel was tricked by the timing or ambushed, they were given it the morning of the first day of trial and then made the argument in the opening statement anyway that there's no evidence, we believe there's no evidence that these files have ever been opened.
And if we ask the defense, is it true, or can you point to any time earlier that you would have made this argument? They will not be able to point to an earlier time?
I don't think I heard your question.
I apologize. If we ask the defendant's counsel, was there an earlier time in the proceedings where they did make this argument? They will not be able to point to that, is what you're saying?
I don't believe so. The suppression hearing testimony was 10:51, and then they made it an opening statement the next day. And then at lunchtime, their expert was there at the trial with them, and they discussed what became Exhibit 6B at lunchtime with their expert. This record was 12:65. 12:65, this is all explained. And then they made that claim again after lunch in cross-examining the government's case agent. So there was no impact from the timing of when they received this. They continued to make the claim throughout trial. They made it a closing.
Why isn't it part of your prima facie case that, pardon me, I should know this, is the crime that they downloaded or that they viewed it? Or both?
The crime is possession.
Okay, so
2252A.
so your view is even downloading it without viewing would be criminal?
I'm not sure. I'd have to look at the statute, but what was charged was possession on the date of the search warrant, October 10th.
But your point is this exhibit was necessary to prove that it was not just downloaded, it was also opened.
Now, that was actually going to be my next point.
Please.
Which is the reason why this was admitted was not because this was critical evidence for the government that the defendant knowingly possessed child pornography on the date charged. It was admitted, and the court explains this at 1265 and 1319. It was admitted because the defendant was making a claim, the defense counsel was making a claim that was incorrect. So the day one of trial, Wednesday afternoon, this is at 1265, the government explains that 6B was created because in the suppression hearing they had made this incorrect claim that none of the files were ever viewed. And defense counsel says, we believe that to be true and we're going to cross-examine the government's forensic analyst on that. And the judge said, that is an unfounded claim. If you make it, then they're going to be able to use this report. The next day, Thursday, day 2 of trial, at the very beginning of trial, the defense again confirmed, we are going to cross-examine the government's forensic analyst with the claim that there's no evidence these files were ever opened, and the court admitted this exhibit. That's 1319. So 6B wasn't put in as part of the government's planned case-in-chief to prove knowing possession, but rather to rebut this incorrect claim that was made the day before trial. So that also goes to the prejudice, that it wasn't really the critical evidence of the case. I think the term might have been harmless. The critical evidence in the case was the over 2,000 images of child pornography.
Doesn't your position, I may be missing a logical step here, doesn't your position imply that it wouldn't matter if the files were ever opened? It was enough that it was on this guy's computer?
That's right. What matters is
that's what makes it not part of your prima facie obligation.
It's not indispensable evidence. What's indispensable evidence is knowledge. Knowledge can be circumstantially inferred from different things. This certainly strengthens the circumstance.
That he knowingly downloaded this impermissible file to his computer, that's the completed offense.
Knowingly possessed was the charge, but yes.
But, right.
So
downloading to your computer would be possession.
Right.
Got it.
So the two pieces of that are that there was pornography on the laptop, that's possession, and the knowledge. And the knowledge is circumstantially inferred from his statements. His statements during the interview that he searched for child pornography, that he viewed child pornography on his laptop, that he viewed child pornography on this laptop 2 days or a couple days before the search warrant. The forensic evidence on the laptop itself confirming that this pornography had been searched for and viewed, that was the evidence of knowledge. This adds to that, but it was created to rebut this claim by the defense. And then I wanted to get to the next part of it, which is the accommodations that the court made. The court continued the trial for 4 days to give defense counsel sufficient time to prepare for the cross-examination of the forensic analyst, Linares. And if you look at 564, we didn't cite this in our brief, but 564 is the defense's analyst's affidavit that was attached to the Rule 33 motion. And he does not complain that he did not have enough time. In fact, he explains that he had plenty of time and he was able to answer the defendant's questions. Judge Ezra put on the record for this court all the accommodations that he made in 1884 to 1898 to allow the expert to testify as part of the defense's case, allow the defense's expert to testify. And I wanted to get to Agent Linares testifying as a lay witness, if I can. So this is the government's second witness. He's a forensic analyst, and he testified as a lay witness. And the reason he did so was because it was the parties' agreement that both of their forensic analysts were going to testify as fact witnesses or as lay witnesses. This is laid out in 3 separate places: 1260 to 1269, 1316 to 1321, and 1884 to 1898. So defense counsel did not object to Linares testifying as a lay witness because that was the agreement. There was no objection before, and there was no objection during. And it wasn't a surprise that he was going to testify about Exhibit 6B. That was the purpose of the continuance, the 4-day continuance, so that they could prepare for the cross-examination of Linares after Exhibit 6B was given over. So they knew that this was coming, and they didn't object before or during. If they had objected, the court could have held that this was lay testimony, the court could have qualified him as an expert, or he could have stopped talking. But they didn't object, so he testified for 4 pages of the record about Exhibit 6B, 1372 to 1375. And then he was crossed for 40 pages. It was defendant that went into technical detail about Exhibit 6B with the forensic analyst Linares. And again, Exhibit 6B wasn't the government's main evidence of knowing possession. That was the defendant's admissions, that he searched for and viewed child pornography on that laptop. As to, I'll move on to Nutt, who's the government's expert witness, who testified on rebuttal. Just want to point out that his rebuttal testimony was pages 1955 to 1966. It was 12 pages. And it wasn't summary testimony. It wasn't an injection of new issues into the case. He answered a series of specific questions, I think on 6 or 7 topics, about what the defense witnesses had testified to. So there's nothing improper about that.
You're going to address the search, the contentions he's making about?
I couldn't hear you.
You're going to address the issues that he argued about the, all these disputed facts about the search and being in custody and so forth?
Sure. So that's, I think the factual citations laid out against the test for whether somebody believes themselves in detention similar to formal arrest or whether there was consent to search, those are in the brief. And then what's raised in the reply brief by appellant is this credibility contest, that this court should believe Michalik and not the agents. And there are a couple of reasons why this court should defer to the credibility assessment of the district court. The analysis is that this court can review the record as a whole to see if the district court made an error in believing the agents over Michalik. The agents testified at the suppression hearing. They were sequestered, and then they testified consistently with one another. Defense counsel was given their notes and given the opportunity to cross-examine them on the notes and didn't find any factual inconsistencies. The consent form that Michalik signed, that's exhibit number 3 at 2238. That corroborates what the agent said. He signed that consent form for his laptop at his office, and he signed that consent form at his house, allowing them to search his car. So he saw that consent form twice. Now, if you compare what the agent said with what Michalik said, he testified at trial. This is pages 1914 through 1916 that I would direct you to. He denied that he searched for and viewed child pornography. So taking it outside of the credibility contest, you can look at the forensic evidence. There's forensic evidence that Linares testified to, 1376, that they found evidence on the laptop that someone had searched for PTHC, which is the acronym for preteen hardcore, using the Bing website. And that's something that the agent said that Michalik had told them, that Michalik denied. He testified, the forensic analyst testified that the child pornography websites were visited. This is the forensic evidence on the computer, which corroborates what the agents say and contradicts what the defendant testified. That's 1377. And then 1363, he testified that Firefox showed that the user of the laptop had viewed a video of child rape. There's also exhibit 5A and 5B, where Michalik initialed those child pornography photos, those prepubescent child pornography photos, and acknowledged that he had viewed them. So those are things that corroborate the agent's account of what happened that day, and why this court should defer to the credibility assessment of the district court.
What evidence was there as to whether the defendant was told at the scene that he was free to leave? And in responding to that, also respond to opposing counsel's assertion that his car keys, that they took his car keys.
So the testimony, the evidence that he was told that he was free to leave came from the testimony at the suppression hearing of the agents. They said that the timeline is that they approached him around 6:30 in the morning. They told him this is a search warrant, not an arrest warrant. But they didn't immediately tell him you're free to leave. They waited about 5 minutes. They took him into the house. They got the rest of his family downstairs. And then they told them all, you're free to leave. You just can't interfere with the search warrant. Both agents said that.
Well, tell us about the car keys and the cell phone. Do you dispute that, or at what point were the car keys and the cell phone?
I think they took, I'm not sure of the cell phone. I would assume they took that right away because that was in the search warrant. The car keys is a separate thing. I don't see in the record when the car keys were taken from him, but I do know from the record that there was no search warrant for the car, and it wasn't until the interview, which took about an hour, that he told the agents, there's an iPod in my truck. And it was after the interview that they asked for a consent, they gave him a consent form and asked if they could search the truck. So until then, he would have had access to the truck. Now, there was something in the record, maybe it was on cross, about how he went back to the house to get his car keys so that he could drive to his office. So maybe he didn't have his car keys with him when he was being interviewed. But the truck was outside of the search warrant, and it wasn't until after the interview that they even looked into it.
All right, do I understand? I'm not trying to put words in your mouth. I'm trying to understand the record. Does the record at any point indicate that the agents, the officers, the enforcement personnel at the scene, at any point took the keys to his vehicle?
The record does not say that they did that, no. And there's nothing that I looked for that, and there's nothing that I saw in the record about that. What I did see was what I tried to explain, that 5 minutes after they approached him, when they had everybody gathered in the family room, they told them, "You're all free to leave." And then they asked Michalik if he wanted to be interviewed in the government's car outside. And then during that interview, he said, "I have an iPod in my truck." And that's when they said, "Well, can we look at that?" And they gave him that consent to search form. And that's when they entered his truck, as far as I could tell from the record. But then there was something further going, maybe it was on cross, where he said he had to go back into his house to get his keys in order to drive to the office. But there wasn't anything about taking his keys. I think it was his common-law wife's mother that drove the child to school that day. So from that, it appears that the cars were free to drive away. There were 3 vehicles there.
Okay, and you spent plenty of time answering that question, so.
Okay. I'll just talk briefly about issue number 3, the sufficiency of the evidence. So we went through in our brief why the evidence was sufficient, and on the reply brief, a different.
Since the charge was possession, not the viewing, but possession, so was the defense that the laptop was accessible by somebody at the office or somewhere else to get him away from the possession, because he wasn't charged with, viewing, downloading, et cetera. Is that what those arguments that somebody else could have viewed the files or put them in there?
That's right. They made the argument that that other people at the office had access to the laptop, and they also made the argument that that the laptop had been hacked and it was being remotely controlled. So those were their defenses for why he didn't have exclusive possession of the laptop. Now, regardless, he still would have had constructive possession, right, even if he didn't have sole possession. He did tell the agents when he was interviewed that it was his laptop and nobody else used it. He did say that. And there was evidence at trial that from other people there that people were using each other's laptops.
Was the jury, among the pattern charges, was the jury given the constructive possession charge as well?
That's right. They were given the constructive possession charge. And then the jury was free to infer that he knew about the pornography on the laptop because he said that he used that laptop to search for and view pornography. So, and the prepubescent nature of the pornography I was just getting to is an enhancement, not an element of the crime. So it's not really a sufficiency of the evidence analysis, it's an Apprendi issue. But the evidence that the child pornography was prepubescent is that 1436, the agent testified that the child pornography was prepubescent, that he had viewed it, he recognized these images, and he knew they were prepubescent. Some of the file names listed ages younger than 12, and that he testified, or he told the agents that he had looked at prepubescent pornography on that laptop and initialed Exhibits 5A and 5B.
All right, thank you, Mr. Gupta. For rebuttal?
Judge Stewart, you had asked for citations to authority that you have to look at the credibility. The interesting thing is, and it's been a debate since Thomas v. Keohane, but also I think it's Casavos, you have to look at the contrary evidence. The point being that it's a mixed question of law and fact, which requires the court for constitutional purposes to make an independent analysis. So that's the authority for that. It's long been held that while you may defer to the court on credibility, it's not an absolute by any means, because you have to look at the countervailing evidence. And we presented countervailing evidence and was unrebutted how the agents acted in reaction to what Juarez and Paula claim was said, because it's directly contrary to what they claim they said.
But it goes back to the question Judge Ho asked. He said, well, if the judge had iterated about everything, would your argument be the same? I mean, you seem to be arguing because the judge doesn't say something about it all, that necessarily means that the judge didn't consider it. And that was the question I asked. I mean, I understand your argument. You have very limited rebuttal time, so push on to your other points.
The other thing about the keys, because that was a specific question, they took the keys at the door. They took the cell phone. So they had the keys. And the circumstantial proof and the direct proof is he had to go back in to get his keys. So they had his keys, so where could he drive? He couldn't drive. So he couldn't go to work and go on to work. At the car, the truck, they never told him, oh, by the way, after you help us, you're free to leave. And Agents Juarez and DePaula admit that. We never told him any of that until he was in the house, and that is why he's already seized and detained.
With respect to 6B, I'd like to address some of the statements by opposing counsel. The statement that the child pornography in Exhibit 6 had never been opened was not a false statement. It was not an untrue statement. The government, of course, bears the burden of showing that things are accessed, and the government concedes that Exhibit 6 didn't show that any of the pornography there was accessed because they had to create an entirely new exhibit to show that it was accessed.
I don't want to get you off track on your rebuttal, but what is your response to the government's assertion that both sides agreed in advance that the expert witnesses on both sides would be treated as lay witnesses?
Not at all. The defense decided against an expert because the evidence presented in Exhibit 6 didn't show that any of it had been opened. There was some discussion of using somebody as a fact witness potentially after this information to come to light, 6B. The government says that it wasn't critical, 6B wasn't critical, but they created an entirely new exhibit to put that in the day before trial.
So, but I just want to make sure that I understand. You're telling us that there was not at any time an agreement by both sides that these would be treated as lay witnesses.
I'm sorry to cut you off, Your Honor, I apologize. The defense had decided against an expert. The government had decided to put in Mr. Linares as a lay witness. That decision about Linares was made independent of the defense.
I'm not sure you've answered the question. Opposing counsel of the government said that you agreed that it would be fine for the government to present Mr. Linares as as a lay witness, and they cited a couple of record sites. Are you saying that that's wrong?
I'm saying that's wrong because what actually happened is when they went to the sidebar before Mr. Linares would testify, the judge had said he's the expert. At that point, defense counsel said he hasn't been qualified as an expert. He's not an expert. He is a lay witness. But that's not an agreement that he is and can testify as a lay witness. Further, defense objected specifically to Mr. Linares interpreting 6B because he was not an expert.
Are you suggesting had the government tried to qualify as an expert that would not have worked?
I don't know if it would have worked or not, but I think United States v. Rebuttal, this Fifth Circuit precedent says you don't get to retroactively designate him as an expert. If he was an expert at trial, he's not expert now on appeal. Now, importantly, though, the government keeps saying that this wasn't critical evidence. It was critical evidence. The jury asked for this link file testimony, misleading testimony from Mr. Nutt 3 separate times and by reference to it. There's no doubt that they resolved any issues that they had because they waited for it for the greater part of their full day of deliberation and then returned a verdict the next day at 9 a.m. I see my time is finished if you have any further questions.
Yes, your time has expired. Your case is under submission. Thank you.
Thank you. It's been an honor.